Not quite sure if you're going to hear this. I might just use this as B-roll. But this is a place called Hell's Mouth, which is rather spectacular. And I am just hiding in one of the little recesses in the cliff because I don't particularly want to fall over down and end up down there. I decided to abandon my cliff top adventures and come somewhere that if I do step off the edge and fall into the water, it's possibly more survivable. But yeah, what I wanted to talk about was this Rwanda bill. Not specifically the underlying sort of rationale itself, I mean not to talk about small boats or anything, but why a lot of lawyers are up in arms about the bill generally. Now, what I would do at this stage is invite you to go and look at my judicial review video, the one I did in the collapsing church. But to give you a recap, generally speaking, courts can't overrule Parliament. What judicial review says is, it's where you challenge and say, look, they're not playing by the rules they themselves set. So if a piece of legislation, for instance, says you are entitled to something, and they deny you that, you can judicially review that decision. Because what you're saying is, well, look, you know, there's no reason not to do this. So that's what judicial review is. But as I said, there's nothing to stop the Parliament changing the law if they disagree with the outcome. So say, for instance, you know, legislation says you are entitled to this benefit, and then they don't give it to people, and the court says that's unlawful. They can change the law to say, okay, nobody gets this benefit. But what's happened with the Rwanda thing? Well, the government have signed up, as a country, we've signed up to the 1951 Refugee Convention, which says you will not send refugees to unsafe places. So you are allowed to challenge and say, well, where you are trying to send me isn't safe. And it's a matter of fact to determine whether it is safe or not. And what might be safe for one person isn't necessarily safe for another person. I mean, this crops up a lot with politics. You know, if you actually support the local regime, then you're probably fine. If you're a political opponent, then it might not be safe for you to go back. Or if you're from a particular ethnic group or something. So that's why, you know, that judicial review was allowed. They said you're not applying your own policy in accordance with your own rules. So what the government has said is, well, right, okay, we are now going to pass law, and the legislation literally just says, as a matter of fact, Rwanda is a safe country, regardless of whether or not it is, or whether there's, you know, that needs to be investigated. Parliament has passed a law declaring Rwanda is a safe country, as a matter of fact. They've also said that this decision cannot be challenged, or indeed no asylum decision can be challenged. Now we've also got the Human Rights Act, and you know, we've signed up to the European Convention on Human Rights. And that allows challenges. But what they've done is they've done what we call an Ouster clause, which is to say that this decision is not reviewable by the courts. They've also got what we call a Notwithstanding provision. Notwithstanding, this might be the factual situation, the courts will act as if it isn't. Okay? Now, what they could have done is they could have pulled out of the 1951 Convention and the ECHR and repeal the Human Rights Act. I mean, you know, that has been suggested by some politicians. But that would be a big step for any government because, you know, when you drill down into it, the Human Rights Act, I mean, I know it gets a lot of bad press, but for instance, that Ruth Perry inquest, one of the reasons that people get legal aid in inquests is because of the Human Rights Act and Article 2. Now, they didn't give legal aid in that particular circumstance, but if that was to be withdrawn, they wouldn't have to give legal aid in any inquest, for instance. So that's what people are up in arms about. It's the fact that Parliament is legislating findings of facts and then saying the courts can't review if they're right or not. We used to have what we call, we still do actually have what we call bills of attainder. These used to be quite a popular sort of mechanism. They're not allowed in America under the Constitution, but a bill of attainder is where Parliament just votes, say for instance to convict somebody. You don't need a trial or anything. A bill of attainder is, you know, the House resolves that Joe Bloggs is guilty of the following offences. All in favour? Aye, right, he's guilty. Churchill actually wanted to use a bill of attainder after World War II for all the Nazis. Ironically, it was actually Stalin who said, no, we should have a big trial. although they wanted it Russian style, which was guilty until proven innocent. But you know, I just thought you might find that interesting. So when you're watching this is what people are up in arms about. It's not particularly about this Rwanda situation. It's the fact that Parliament is setting a precedent, because as people have pointed out, Parliament, because nothing can stop Parliament passing legislation saying, regardless of the results of any election, as a matter of fact, we have won. And although, you know, you can challenge things under the Representation of the People's Act, we actually oust that. So you say, and there can be no challenges in court to that. So that's what people are sort of, you know, slightly worried about. That it's not this specific case, it's setting a very dangerous precedent for the future. So there you go. As always, hope you found that vaguely useful and vaguely interesting. This is the old gunpowder works again. I just thought I'd come here because, like I say, it's a fairly safe place and it saves stepping off the edge of cliffs and stuff. So I'll step out of the way and have a little look. Ooh. Ironically, it nearly did just step off the edge of the riverbank then.